Hello and welcome everyone to the in new series of Drishti IAS. My name is Pragya. In today's episode of this in new series, we are going to discuss a very contentious and a recent issue. The title of our today's discussion is the central government has finally implemented the Citizenship Amendment Act of 2019 by notifying the official rules regarding CAA in the official gazette. So in this discussion, we are firstly going to study about the news. Then we are also going to understand the main provisions of the citizenship law that was amended in the year 2019. Then we are also going to understand the CAA rules. We are also going to understand the premise of the legal challenge that is against this law before the Honorable Supreme Court of India. Then we are also going to see a relation between CAA and Assam. Why is Assam protesting against CAA? And lastly, we are going to discuss a practice question for your prelims examination and a practice question for your mains examination. So if I talk about the background of our today's topic or the news, so the Citizenship Amendment Act was enacted in 2019 and the law was notified in the year 2020. So basically, after 4 years of its enactment, the central government has finally implemented the Citizenship Amendment Act of 2019 by notifying the official rules regarding the same in the official gazette. So basically, the Union Home Ministry is also mulling a digital platform through which citizenship will be given to the persecuted minorities of our various neighboring states. So this issue is very contentious in nature. Many of who can forget the anti-CAA protests, and definitely the protests are still ongoing in the northeastern states. So this brings us to the important point of our today's discussion, that what are the main provisions of the citizenship law which was amended in the year 2019. So basically, through this amendment in 2019, we are trying to give citizenship to the persecuted minorities. Who belong to the neighboring nations of Afghanistan, Pakistan and Bangladesh. And these persecuted minorities include the Hindus, Buddhists, Jain, Sikhs, Christian and Parsi community. So the people who are there from these religions, they are considered to be persecuted minorities in our neighboring states, and we are trying to give them the benefit of Indian citizenship because some way or the other they have entered into India and they are in a state of statelessness. They do not have their official identity, and it is very difficult for them to avail of any government scheme, avail of visas, etc. So finally, the central government in 2019 decided to amend the Citizenship Act of 1955 to give them the Indian citizenship if they have entered India before December 31, 2014. Moving forward, this amendment relaxed the eligibility criteria for citizenship for certain groups based on their religion and country of origin. So the government has said that as they belong to a country that has just one religion in priority, and they are facing various issues there. They are facing persecution, they are facing discrimination, and somewhere or the other they have already entered India. So that is why we should give them the citizenship so that they do not remain forever in the state of statelessness. They should have their own identity. And the Citizenship Amendment Act of 2019 has also decreased the criteria for naturalization from 12 years to 7 years. So this criteria was also relaxed by the CAA Amendment Act of 2019. Okay. However, certain areas such as tribal areas in Assam, Meghalaya, Mizoram and Tripura, as well as regions protected by the inner line system, were excluded from the provisions of this Citizenship Amendment Act. So see, inner line provision is a colonial concept. This means that you are protecting the majority of tribal areas from the plain areas. Plain areas. And for entering these kind of tribal areas, you specifically require the inner line permit. Okay, and that is why these kind of areas were excluded from the operation of the Citizenship Amendment Act of 2019. The law, as I said, was notified on January 10, 2020 amidst protests around the country, particularly in Assam, but could not be implemented in the absence of the rules. And finally, the central government has paved the way for its implementation by notifying the official rules. So this brings us to the another moot point of our today's discussion, that what exactly are these CAA rules that have been notified by the central government. So basically, the first thing is, who can apply for citizenship under Section 6 Clause B of the Citizenship Amendment Act of 2019. So basically, there has been a specific criteria that has been laid down under Section 6B of the CAA 2019 for those persons who want to apply for the Indian citizenship. So the person is of Indian origin. Okay, the person is married to a citizen of India. The person is a minor child of a person who is a citizen of India. Moving forward, the person's parents are registered as citizens of India. The person or either of his parents was a citizen of independent India, and the person is registered as an overseas citizen of India card holder. So these persons are eligible to apply for Indian citizenship through the way of naturalization. Moving forward, the new rules suggest that those applying for Indian citizenship will have to submit two special documents. So an Indian citizen will have to testify to the character of the applicant via an affidavit. Okay, and the applicant must have adequate knowledge of one of the languages listed in the 8th schedule of the Constitution, and he should also sign a declaration. That he will have no relations to his original country if he is granted the Indian citizenship. And all of these documents will be verified by a special committee. And after conducting a due inquiry, it will finally be decided that whether they are eligible for Indian citizenship or not. Moving forward, let us examine the premise of the legal challenge that is there against this law before the Honorable Supreme Court of India. So, in 2020 itself, a petition was filed by the Indian Union Muslim League. Indian Union Muslim League. Before the Honorable Supreme Court of India, and as of now, more than 200 petitions are attached with this main petition before the Honorable Supreme Court of India, and these include the petitions by various opposition leaders and various prominent personalities as well. Okay, so it is premised on the ground that it is against Article 14, which gives us right to equality. So if you read the Article 14 and if you observe the right to equality in detail, that means the state shall not discriminate anyone on the ground of race, religion, caste, place of birth, sex, etc. So discrimination on these grounds is specifically prohibited under right to equality, which has been enshrined to us by our Indian Constitution. So basically, the petitioners argue that using religion as a qualifier or a filter violates the fundamental right to equality. So whenever there is a test of right to equality before the Honorable Supreme Court of India, the Honorable Supreme Court of India examines the law on two broad tests. Okay, so the two tests are, firstly, any differentiation between groups of persons must be founded on an intelligible differentia. So these are the grounds of what? These are the grounds of reasonable classification. Okay, so reasonable classification is permitted under Article 14 of our Indian Constitution. But to satisfy the test of reasonable classification, to satisfy the that the law is based on reasonable classification, you have to fulfill these two tests. So first test is of intelligible differentia, and secondly, that differentia must have a rational nexus to the objects thought to be achieved by the act. But in this case, the petitioners are arguing that you are specifically excluding just one religion. Excluding just one religion. So what is the purpose that is being solved by you by just excluding one religion? Because if you talk about the Rohingyas of Myanmar, they are excluded. Only the certain religious groups are entitled for the Indian citizenship, and one particular religion has been excluded. The petitioners also argue that yes, it also violates secularism, because you are using religion as a filter. And secularism has been declared as the basic structure of our Indian Constitution in the S.R. Bommai versus Union of India case. So these are the grounds on which the petitioners argue that yes, there is a clear-cut violation of right to equality. But if you talk about the government's stand, the government is saying the countries in which we are giving the persecuted minorities of which we are giving the Indian citizenship are in minority there. They have just one religion and they are facing various kind of issues such as discrimination, such as persecution, and they have already settled in India. So we have a reasonable classification in favor of them so that we can grant them the Indian citizenship. So on these premises, broadly these premises, the legal challenge against this law is there before the Honorable Supreme Court of India. Moving forward, let us understand the relationship between CAA and Assam, because there are ongoing protests in the Assam regarding the implementation of the Citizenship Amendment Act of 2019. See, apart from the equality argument, part of the challenge to the CAA also rests on the fate of Section 6A of the Citizenship Act 1955, which too is under challenge before the Honorable Supreme Court of India. And the Constitution Bench of the Honorable Supreme Court of India has already reserved its judgment in the case. Reserved its judgment in the case. So basically they are saying it is in complete violation of the Assam Accord that has been signed by the central government and the leaders of Assam in the year 1985. So as per clause 5 of this Assam Accord, a person will be treated as a foreigner. Okay, if he has not entered India after January 1, 1966, but he can apply for naturalization till the March 24, 1971. Okay. So, as per clause 5 of Assam Accord, what are the base cutoff dates? January 1, 1966 and March 24, 1971. So, supposedly in this case in which the Section 6 Clause A of the Citizenship Act 1955 is challenged, the Supreme Court accepts that March 24, 1971 as the base cutoff date, then definitely CAA will violate the Assam Accord, because it sets the base cutoff date as December 31, 2014. Okay. So there is a clear-cut conflict between the CAA and the Assam Accord. And there are, tensions regarding the insurgency as well. The people who are living in the northeastern states are basically tribal people. They are saying that you are allowing such a huge influx from Afghanistan, Pakistan and Bangladesh, And if you talk about the people from Bangladesh, they are Bengali speaking people. So they fear that they will replace the tribal culture. They will replace the tribal people from their own native land. They will take their lands, they will take their jobs and etc. Okay. So that is why it is being said that CAA should not be implemented in the tribal areas of Assam and the other northeastern states. And that is why they are protesting against the implementation of the CAA. So with this, we come to a conclusion of our today's discussion. We have discussed that yes, finally after 4 years, the rules have been officially notified by the central government in the official gazette. We have also seen the main provision that yes, the CAA was there to grant citizenship to the persecuted minorities in the three neighboring countries, namely Afghanistan, Pakistan and Bangladesh. We have also discussed the broad premise on which the law is challenged before the Honorable Supreme Court of India, and we have also understood that how CAA will be in violation of the Assam Accord if this judgment is passed by the Honorable Supreme Court of India. Now let us discuss a practice question for your prelims examination. So the question is, in which list of the Indian Constitution is this citizenship included? Your options are option A is state list, option B is union list, option C is concurrent list, and option D is none of the above. So kindly drop your answers in the comment box below. Now let us discuss a practice question for your mains examination. So the question is, critically analyze the grounds of legal challenge against CAA. So you firstly will write what was the CAA amendment all about. Then you will write the grounds of the legal challenge, such as it is against the right to equality, against reasonable classification, against secularism, etc. And you will discuss them all in brief. And then you can conclude that it has still to be found out by the Honorable Supreme Court, because the two tests of reasonableness should be fulfilled by any law. And the Supreme Court, the matter is still sub judice in the Honorable Supreme Court of India. And if it is found that the law is arbitrary in nature, it will definitely be struck down by the Honorable Supreme Court of India. So you can conclude very holistically. I hope this session was insightful for you. If you have any feedback regarding this session, you can drop it in the comment box below. If you liked the today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such interesting updates. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.